Pending before the Assembly right now is a bill that would both correct some of the problems, such as the requirement that landlords provide an itemized description of the premises to tenants. That's how the law has been interpreted, at least. The Assembly bill would make clear that they do not need to do that. It would also speed up eviction processes by imposing shorter deadlines and mandatory deadlines, and would open up the doors for landlords to use agents rather than full-time employees to represent them in court. So it would reduce the role of attorneys, reduce costs to landlords, make things faster for evictions. I'm Briane Pagel. I'm a shareholder at the firm of Kreckler Struther here in Madison. I practice exclusively consumer litigation, primarily from a debtor's standpoint. I've been doing this for 15 years now. I presented on Act 143, which was the legislation that substantially amended Chapter 704 of the Landlord Tenant laws in the state of Wisconsin. The real focus was whether Act 143 made enough changes in landlord tenant law to drastically affect how those cases are litigated, and was it actually necessary given what it appeared intended to do in terms of correcting problems that were perceived in landlord-tenant litigation. Act 143, I think, was primarily intended, based on what I'm reading about it and the changes it made, was primarily intended to smooth out some of the wrinkles that had come up in landlord-tenant law, clarify when a lease might be void, for example, and when it might just be severable, to make it easier for landlords to understand what provisions they could put in, and also elaborate on rights that tenants had gotten over the years. So I think that was the intended goal. I think whether it did that was superseded by the fact that it opened up not just residential litigation, but expanded to apply to commercial litigation, and left some areas where there's the potential for additional litigation beyond that, such as whether attorney's fees can be charged in a commercial context, and whether landlords have to provide specific itemizations when they move in. So I think the imposition of the law, while it smoothed out some areas, created whole new areas that now will have to be addressed in the future. Number one is, of course, always sit down and read through the statutes, but it's helpful to do, and what we did a little bit of in the presentation today, look at some of the landlord-tenant cases you've had in the past. It's always easier to read a statute with respect to specific facts. So when you look at some of the bigger cases that all landlord-tenant lawyers are aware of, kind of read through the statutes and parse through how those would have been affected. You know, would a lease still be void as in those old cases? Would a landlord still automatically get these deductions or not get those deductions? So read the statutes, but think about them in context of these big cases that we all know, because it's easier to see the changes that have come about then.